actually read the canons and kind of explain them so you understand what they are. And you also understand which duty they're reflecting because they don't tell you the duty in the canons. It's just something for you to figure out. Okay. All right. So the first duty for you is the duty of competence. And if you recognize here, the attorney also has a duty of competence, right? So both of you do. Um, The Bar Association focuses on the requirement that attorneys provide able representation to their clients. And I kind of explained to you about the criminal law attorney taking on a contracts case. Same thing with the criminal law paralegal taking on a contracts case. Okay. Competency requires knowledge of the law, careful research to ensure being up to date, and proper preparation for representation. Okay, so that's what they're looking for. It's not like they want you to go take classes and spend 5 hours. No, they just want you to be, to show them that you have knowledge of the new law that you're trying to establish with the client, right? And for you as a paralegal, you still have to know contract law. If you're going to be filling out and filing documents for contracts, you've got to know a little bit about the law too. Maybe you're going to have to go up and, go back and kind of brush up on that law too. Okay. Careful research. Yep. Paralegals do research, and we have to make sure that now we learn how to do contract research. What are we looking for? What case is on point? Is it a breach of contract? All of that, okay? And proper preparation for the representation. Now, spending 10 minutes on contracts and looking it up online really quick, what is a contract, is not proper preparation, okay? Proper preparation means that you're taking the time out to figure out how do I properly, file this document? What documents do I file for contract law and so forth? Okay, that's proper preparation for the representation of the client. Same thing goes for the attorney. Most legal representation occurs out of court, but requires the same knowledgeable approach. You're not always going to be in court. I think I explained that to you the first time. You will not be a trial paralegal unless that's your job title, trial paralegal, and you're always in court. That's different. Or maybe you work for the court system. You can always be in court. But with attorneys, they like to settle out of court, depending on the situation, the dynamics, the damages owed, things like that. Okay. But you have to be knowledgeable, even if you are going to step in the courtroom for the first time and you've never done it before. You still have to do your proper preparation for that representation too. How do I even start? How do I do the trial notebook? What do I bring to court? Am I responsible for bringing a laptop? Am I responsible for the PowerPoints? All of that. Okay? Any paralegal who doesn't prepare properly has violated the duty of competence. So if I give you an ethical question for classwork, and there's a paralegal who did not properly prepare for anything, for the document, for the filing, whatever it is, right? That is not proper representation. So what is the violation there? It's a violation of the duty of competence. Those are the kind of words I want you to use when explaining to me what happened. Okay? Most legal representation occurs out of court. I just said that. A breach of this duty may subject attorneys or paralegals to one or more of the sanctions discussed earlier. As a paralegal, you share in this duty when you work on an attorney's behalf. You're working on an attorney's behalf all the time. For the first 2 years of your new career, you're working under an attorney's behalf. After 2 years, you can make a different decision. You could be working for a lot of attorneys as a freelancer or an LDA, a legal document assistant, and just working for the public and filling out documents. But there's rules and guidelines for that. But most of the time, you will be working under the